on. Hi, everyone. Jeff Krieger with Matt, if you didn't already know that. Glad to see all of you here. I know I haven't been here for a while. And hey, Pat, how you doing? And I've been traveling a little bit and doing some other things. So I'm glad that Graham, Steve were able to fill in for us. Has everyone met Maddie? Has she been introduced, Graham and Steve?
So we did introduce her to the Township Tuesday folks last time briefly. Yeah.
Okay, great. And we are thrilled to have Maddie with us. And I think it's been, 3 weeks? I think this is the start of your third week.
Yes, this is the start of my third week.
Yep. So everything is just working great. And then she's gravitating to Township business really well. I just have a couple of things I want to announce to you. And she's still here. Yes, Pat. She made it past 2 weeks. Thank God, right? But we do have the L&R committee meeting that's going to be tomorrow. Everyone, if you are interested in doing that, it's from 9 to 11. Or actually, it's 9 o'clock till however long we need to go. But everyone does need to register separately. So if you are interested in being involved in that, we just have 2 resolutions that we're going to be going over. We'll go over legislative updates, some of which I'll be doing today. But we'll have Shep on there talking about the state stuff. I'll be talking about federal legislation, and then we can talk about the resolutions that are there. Of course, annual conference, always want to pitch that December 7th through the 9th, Thursday through Saturday, or just to like noon or so on Saturday. So it's not going to be all day Saturday, but we did go back to a 3-day event rather than 2 days, what we had last year. So please, feel free to, I don't know if we have the registration open for that or not.
Not quite yet.
Okay, thank you, Leslie. But we'll have that up soon. So everyone will be able to go in and register as they want to. It will be back in St. Cloud as it was last year at the Rivers Edge Convention Center. And we're looking forward to a good event. We have a lot of good speakers lined up for that. And I believe actually we're going to throw Maddie to the fire and let her do a presentation too. So you'll be able to see her in action. And I know you'll definitely enjoy that. We have something happening at the Capitol. Obviously, the Capitol is in interim session right now, or interim between sessions. So nothing really happening, but we are gearing up, trying to get things firmed up as far as on the outside, looking in as far as with transportation funding, annexation reform. We have to get going on that this year. Last year, if you recall, we had 70 new legislators that we had to reintroduce to or introduce to annexation and get them to understand why that's such an issue for us. But so I know that we are starting, and Graham especially is really hitting the ground running on that. And since he's going to be doing the heavy lifting in the day-to-day legwork when it comes to that stuff. But we are looking forward to making some headway with that. One thing I do want to remind people too is that if an issue comes up, we need you to talk to us and get us involved if we can get involved. Good case in point, we have an issue in Scott County where MnDOT initially was trying to get a township to take over. This is a bridge that has not yet been constructed, but MnDOT's trying to get a township to take over or at least half the major maintenance of this bridge, as well as all the minor maintenance. We could be talking about this township when it comes to a major maintenance, doubling their levying for road funding, and obviously we just can't have that happen. Plus, it's over a trunk highway. It just has never happened before in the history of Minnesota, and it's just too devastating for townships. So those are the type of things we do want you to get us involved in. Because this could have statewide implications, and we want to be of assistance to you. I have had a couple of trips to DC. This actually last month of September, talking about bigger trucks. Obviously, broadband transportation funding is always a big one. We're looking at trying to see how we can get some set asides, specifically for townships and townships of our size, under 5,000 in population for the most part. And but again, broadband. Volunteer drivers, that one's hitting some good motivation for us, and or momentum, I should say. And even Klobuchar came out publicly for the first time where she is going to back volunteer driver legislation, and so that's huge to have Klobuchar on board with us. Vance Bachman came with Gary Burdorf and myself for my second trip. That was the 19th to the 21st of September. And Vance was able to talk quite fluently about the EMS crisis in rural Minnesota. And so he was able to really put put a face, put good stories behind why this is so troubling for us as townships and us in the rural areas. The other thing is, we also have rural definition change. Right now, the rural definition of rural in this country is between 50,000 and 200,000 in population. Depends on what legislation you're talking about. It could go down as low as 5,000. Again, depends on which legislation you're talking about. But for the most part, it's between 50 and 200. And we're trying to get through Representative Fenske, he's the one that's authored this legislation, is to lower the rural definition down to 20,000 in population. So that'll definitely help us. So we don't have to compete against the larger cities when it comes to Fed dollars. Now, there's still the challenge of doing grant applications. And that's a whole nother animal that we need to work on. And but that'll be coming in the mix too, to either ease regulations or ease the requirement for applications or get assistance on that. And the last thing that I have talked about is definition of bridge, or what is the definition of a bridge in federal terms. For state, it's anything that's 10 feet or above in length. And but the federal definition is 20 feet. And so we're trying to get that definition lowered down to 10 feet as it is in our state, for that. Again, helping with federal dollars, possibly going towards bridges in our townships. So, but other than that, I don't have any other things to add. Let's see in the chat, Leslie. Okay, awesome. And I don't know, Graham, are you up? Are you going to be doing a presentation?
I am, yes. So we've got two presentations for you folks today. Just some two little bite-sized ones here. So let me go ahead and share my screen, and let's see if we can get this thing rolling here. All right. Just a moment. Sorry about this.
As always, if you have any questions, feel free to chime in if you want to unmute yourself, or you can put it also in the chat, and we'll try to have Graham or Maddie or Steve look at those as well.
Okie dokie. I apologize, folks. I am having a little bit of technical difficulties. Tell you what, Maddie, are you ready to go here?
Yeah, I can go. No problem.
Let's go ahead and do that.
Okay. Let me see. Sure. Okay, so can everyone see the slideshow here?
Yeah, we can see your screen. Maybe you meant to put it in a slideshow.
Yeah. Sharing, it's not going. I went to the wrong screen. Hold on. All right.
We could go to the third option here if Maddie needs time.
Well, I think Maddie had it. She just click the slideshow, start slideshow up on top of your screen. So open up your PowerPoint and then share the screen and then click share.
Okay. Share screen.
I can help you. It's a little wonky. Yeah, so go into there and then go to slideshow and then you got it.
Did it work?
It did
Because it's
not.
working on my computer, but it's not working on the thing, huh?
This will be fun. This looks fine if you want to share it from here, Maddie.
Okay, yeah, this is fine. It doesn't make much of a difference. Okay.
Nope.
So in the couple of weeks I've been here, I've had a lot of questions surrounding meetings and the required notice for the meeting. So I thought that for a refresher for me and for you guys, that we could walk through that together today and hopefully answer maybe some questions that you would submit to me or otherwise. First of all, as Jeff said, I'm Maddie Cash. I'm the newest attorney here, and my extension is 105. If you have any questions, please give me a call. I'm happy to work through any issues or concerns that you might have and try to figure those out with you. So when it comes to notice and meetings and following the open meetings law, it's really important to pay attention to what your requirements are, because any decisions that are made at an improperly noticed meeting are invalid and can be considered just not valid and unable to be actually put into action. And any participating officers who are in the meeting know that they weren't following the open meeting laws could face some serious legal consequences, those being civil penalties. You would have to pay fines that the town wouldn't be able to reimburse you for. So it's important to pay attention to what those requirements are. Now, when it comes to regular meetings, as you guys probably know, the board should adopt a schedule for their regular meetings, and the town should keep that on file in their primary office as to what that schedule is. And a copy of the schedule should be posted in the town's principal place of posting, wherever the public can view it, typically where the board is meeting on a regular basis. So the schedule should also include any other meetings where the board is meeting in a quorum or more supervisors regularly. One example would be the town's planning commission. If there's any other meetings where board members are discussing town matters, those should be included on the schedule as well. And if the day of the meetings falls on a holiday or for some other reason the board can't hold a meeting on the regularly scheduled day, it's important to remember to designate an alternate day so that you don't have to give the notice required by a special meeting. Okay, annual meetings. As you guys probably know, every town must hold an annual meeting on the second Tuesday in March. If there is bad weather on that Tuesday, which there typically is a lot of bad weather in March in Minnesota, so the town board could set another date within 30 days where the weather is better. The clerk must give 10 days published notice of the meeting's date, time, and place in a qualified newspaper that's regularly circulated throughout the township. It's important to create an agenda where it lists all of the business or decisions that will be made in the annual meeting, but the agenda doesn't have to be published. It should just be available once attendees are at the meeting. A lot of towns hold the annual meeting and the election on the same day, and that's perfectly fine. That's great, but it's important to ensure that those activities don't overlap. So for most towns, the polls are open between 5 and 8, so it's good to schedule the annual meeting outside of that time frame if you're doing it on the same day as the election. To hold a special town meeting, towns usually have to hold these meetings just to address any issues that arise after the annual meeting or after a regular meeting, to make follow-up decisions. And notice for these kind of meetings need to be posted with 3 days notice, but we actually recommend 5 days notice because that 3 days doesn't include the date in which it was posted and the date of the actual meeting. So, and that notice should include the date, time, and place and purpose of that meeting. Closed meetings have the same notice requirements. If the closed meeting is held after that open meeting, they need separate notice requirements, and the attendees in the meeting can just notify that this is the beginning of the closed portion of the meeting. Emergency meetings can be called if the circumstances with the judgment of the board require immediate consideration. Think safety or health concerns. These do not require posted or published notice. All they really require is a good faith effort to notify any news mediums which have requested such notice, if it's reasonable and when it's reasonable. The notice should include why this emergency meeting was called and the circumstances surrounding it. If a meeting is recessed or continued, takes too long, the time and place for that reconvening of the meeting should be established during the earlier meeting. Towards the end, there's no published or mailed notice requirement for these continued meetings, but there's no language surrounding posted or personal service notice. So if you're unsure, you can never over notify people. So that's always a good option. And that's everything that I want to share with you guys surrounding meetings and notice. This is my information. Again, I'm Maddie Cash, mcash at minnesota-townships.org, and my extension is 105. Please give me a call if you have any questions. Did I stop? Did it work? Stop sharing?
All
That's all.
right. Thanks,
You're out
Maddie.
of it. Thanks, Maddie.
Yeah.
So hopefully I have got my issues worked out here. Let's see if we've got this one working. All right. Can everybody see my screen okay?
Yes, we can.
Yeah, looks great.
All right. So today we had a bit of a specific question come in from our beloved Director Wells, which is this. So what procedure must the town supervisor go through to inform the township if they have potentially an interest in a fire contract? So let's start talking through this as a hypothetical here. Now, of course, obviously, our members, our township officers, are the sort of folks who show up, the kind of people who care about public service and their neighbors and all that kind of stuff, which is great, and we love it. But it does have it does have some certain implications, particularly with respect to the fire service. We find that disproportionately, our membership turns out to be folks who are also volunteer firefighters. Now, this may surprise folks who are not familiar with the fire service in Minnesota, but volunteer in this particular context doesn't necessarily mean volunteer in the way that you and I would use it moment to moment. Now, I don't want to pick on any jurisdiction in particular, but what you are seeing here is a presently active, or at least it was active as of yesterday morning, advertisement for a quote volunteer firefighter position in a city that serves a number of townships here in Minnesota. And as you can see, this particular position would result in someone actually receiving compensation for their service as a volunteer firefighter. Now, just in terms of giving you a scale, a sense of how common this is, Minnesota is actually, interestingly enough, the second most volunteer heavy state in the entire union. Delaware has more volunteers than us, proportionally speaking, but for a big state, we have a ton of volunteers. Now, these figures come from 2017. They were the most recent figures that I could find. This is from a volunteer retention pilot program report to the Minnesota legislature by the State Fire Service back in 2017. But the long and the short of that report is that lots of departments around the state are finding it difficult to retain people, and as a result, they are trying to figure out ways to compensate people, and this arrangement is becoming more common over time. So what happens when if we're township supervisors and we're in one of these quote volunteer unquote positions and the fire contract comes up for renewal? Now, I want to emphasize before we get into this that getting paid for the actual services of being a firefighter is not the only way that a board member can have an issue like this come up. Obviously, if you're the guy who's selling the town, fire apparatus, you might want to think through this analysis yourself. But for the purposes of today, we're going to, I think, walk through the most common hypothetical, or the one that comes up most often, at least in the questions that get to me. So we've got an issue. We're on the board of supervisors, or we're a supervisor. We're dealing with a fire contract. We are potentially paying ourselves. So, of course, it is time for the statutory hokey pokey. We've got ourselves two sources of conflict of interest law in the state of Minnesota. Two broad analyses, and then within one of those, two broad sources. So there's the common law conflict of interest analysis, which we're not going to go through in any depth today, because I think the statutory conflict of interest analysis is the one that we care about. And that statutory conflict of interest analysis sort of starts from these two sources of authority. So we've got Minnesota Statute 365.37, except as provided in Minnesota Statute 471.87 through 89. A supervisor may not be party to, directly or indirectly interested in a contract made or a payment voted by the town board. And then we have the general statute 471.87. Public officer who is authorized to take part in any manner in making any sale, lease, contract in any official capacity shall not voluntarily have a personal financial interest in that or benefit personally, financially therefrom. Both of these prohibitions are criminal in nature. Both of these are pretty darn sweeping. That's some pretty broad language there. So this is kind of where our analysis starts, and this is sort of why I call it the statutory hokey pokey. So anytime that we're potentially paying ourselves, we need to start paying attention to these prohibitions. Our hand is potentially within the circle, and now we have to figure out a way to get out of the circle. So applying our hypothetical fact pattern to this set of rules, we've got ourselves a member of the Board of Supervisors. He's one of the folks making decisions for the township. We know from ETO versus Town of Marion that qualifies potentially as a public official within the meaning of the 471 statute. We've got a payment, which may be, or at least the cautious approach is to count this as a personal financial interest or a personal financial benefit. So our hand is potentially in. Now we need to think about ways to get our hand potentially out. So those of you who have seen presentations of this nature before, or who have particularly sharp eyes, will have noticed that in our two statutes here, 471.88 is listed as sort of the nature, or as the source of potential exceptions for our criminal penalties. And now, of course, there are two potential big ones. Now, those of you who've heard me talk about this before will have heard me talk about this one, Subdivision 5, a contract for which competitive bids are not required by law. So this is in our list of exceptions. If you were just reading this thing, you might think, all right, great. I am not getting paid $175,000 per year. Therefore, great, no competitive bid would be required by this under MCL. Therefore, I am within the ambit of Subdivision 5. But as Billy Mays would say, but wait, there's more. Here is Minnesota Statute 471.89, which is coming in to modify our understanding of that Subdivision 5. So that statute tells us there are certain requirements in order to use Subdivision 5. The conflict must be, the board must authorize the conflict. That authorization must come through a resolution, and that resolution must include certain items. It must state the essential facts. It must include a recitation that the contract price is as low or lower than the price at which the goods or services could otherwise be obtained. Now, there are additional requirements for people who are actually going through this process. Before you get paid, you need to file an affidavit, and that affidavit must itself include certain items, name and title, itemizing the goods or services, reasonable value, disclosing the interest in the contract. Now, this is one that seems a little silly in this context because, of course, our interest in the contract potentially is I'm a supervisor and I am potentially paying myself through this cutout. But it's really designed for situations in which, for example, a supervisor owns a company or owns a smaller share in a company. So these interests can be a little bit hidden. So you're supposed to disclose that. And then you have to promise under penalty of perjuring, of course, as with any affidavit, that to the best of our knowledge, the price is as low or lower than the price at which goods or services could elsewhere be obtained. Now, one of the interesting bits about this particular question comes from Minnesota Statute 471.88. Now, this is one that we haven't talked about since I've been on Township Tuesday, and it's a little bit of a weird provision in 471.88. And the legislature has just sort of very explicitly given volunteer firefighters their own special weird little exemption. It's subdivision 6, that's a direct quote, that's the entire subdivision right there on your screen. A contract with a volunteer fire department for the payment of compensation to its members or for the payment of retirement benefits to these members. So getting back to the focus or the heart of the question here, the meat of it was about notice. What do we have to disclose? When do we have to disclose it? And hopefully it'll become clear why I set up the answer in the way that I did. Because there isn't actually a statute that says you must give notice and this is how you must give notice in this particular case. It's something that falls out implicitly of the requirements of getting our hand out of that hokey pokey circle. Depends on the method that we choose, and that method in turn depends on the facts of the particular case at issue. So if you are using subdivision 5, we have ourselves a time standard here, quote, in advance of performance. So that's when the resolution needs to be passed. And we've got a list of items that resolution needs to contain: the essential facts, this recitation about the price being as low or lower. Now, if we're using subdivision 6 instead, those provisions don't strictly apply. I mean, like, look, it's not a bad idea to grab 2 exceptions instead of 1 exception, because, of course, if you end up in a position where you haven't done an exception correctly and your hand is still in the circle, you are technically committing a gross misdemeanor or a misdemeanor, depending on which of those 2 provisions someone decides to pay attention to. Instead, if we use subdivision 6, what we have is the unanimity requirements from subdivision 1 of 471.88. So, you know, we are potentially changing the nature of the vote on the contract from a majority rules kind of situation to a unanimity situation. But we have implicit in those requirements a certain sense of notice. So in advance of performance, the board has to pass a resolution containing certain items. So presumably you, interested officer, have to give them enough information to pass that resolution. That's why I say this stuff sort of falls out of the exception rather than being something that's explicitly in it. That said, in this case, if you are looking at something like this, there are a couple of questions you're going to want to ask yourself. Is the local department a, quote, volunteer department, unquote? Because if you're not, then you are probably within the ambit of subdivision 5 and not subdivision 6, and it changes the amount and type of information that you have to give to the rest of the board. If you are benefiting in some way other than, quote, compensation, unquote, or retirement benefits, then you are probably outside of the ambit of subdivision 6, and you're going to have to go through the subdivision 5 process. Of course, if you just want to be cautious, belt and suspenders conservative to avoid risk, and want to pile up 2 exceptions instead of just 1 exception, you might want to give it anyway. You might want to go through this process, the subdivision 5 process, and give notice, including you know, enough stuff to tell them in advance of performance to set out the essential facts of the contract, and to get that recitation that the services are as low or lower than they could otherwise be obtained. That said, when you're dealing with a volunteer fire department, as most of our fire departments are, you can use subdivision 6, which doesn't require that sort of paperwork. So, any questions? Let's see. Excuse me.
Thank you, Graham.
Go ahead
Appreciate
and
that.
my screen share here.
Any questions for
All
Maddie,
right.
or Maddie, for Graham, for myself, Steve? Quiet bunch today.
All right.
It's all right.
Well,
Anything from anybody else, from Maddie or Graham?
I was gonna go through the proposals there, Jeff.
Oh, yes, thank you. Oh my gosh. Thank you. Go ahead.
Hey, everybody. I am opening up our document here. So the board has approved a set of bylaw, a draft set of bylaw changes to offer to the members. And that's something that would come up at the annual meeting, but we want to talk about them and have you all look at them in advance of it. It's not just a get there at the meeting date. I'm looking for a discussion here. This will be the first time anybody's seen these outside of the board. So we want to hear comments and questions and all that. And my goal is to get things answered before the annual meeting, so that people don't show up that day and then start having this discussion on a Saturday morning when we know they're all really waiting for the door prizes and they want to leave. Okay, so I'm going to go through this and give you some sense of what's in there. The problems we've got can be broken into, I guess, well, 3 sections. Okay, there are problems that we address in this thing. There's an option to add or remove something that's not a problem, but it's just an option. And then there's a bunch of just grammatical, stylistic stuff. Okay, bylaws change over time. Since 1981, our bylaws have changed 23 times. And it used to be on average every other year that they did this. We haven't done it since 2016. It's really been some time. So there's a lot here, and it's going to look like that. I don't think it's quite as bad as all the blue ink makes it look. Graham, can you confirm you guys are seeing the draft bylaws?
I can see you just fine.
Thank you. So this first page is just stylistic stuff. Okay. Board of directors, we changed to, because it wasn't consistent of what was the board, Matt board, the board of the association, Matt, we've just gone to board. Okay. A simple change. You'll see it show up over and over because it's referenced a lot. Here again, stylistic stuff doesn't change what we do or what we offer you. And overall, anything in here doesn't change our services. The services are the same. The intent of this thing, right, these bylaws is a guiding document to let us have some rules, but also some flexibility to make sure we can do what officers need us to do. Okay. First thing, membership. We've had a lot of issues with what's a member, who's a member. Is it the townships themselves who pay the bill, or is it the voting officers? So it's our understanding that the members are the townships, the Minnesota Association of Townships, not township officers, right? And it was in the past township officers. Well, our organization is of townships, but we want to ensure that the members get a vote. So what I've done here is restate. You'll see a bunch of crossed out stuff. Okay. It's incorporated into that new section 1. Okay. Nearly entirely. And it just says the towns are the members, but the voters of Matt will be the supervisors, clerks, and treasurers. And then if a clerk or treasurer is absent and their deputies filling the role, the deputy gets the vote. Okay. But it makes certain that we're serving even the deputies who don't get a vote in our meetings. We still provide them services. Okay. It explains membership's a privilege. This isn't a right. It's something that people can join and they can leave. And likewise, Matt can decide what's in its best interest for membership. So one of the items removed, it's not a problem, is honorary membership. You'll see in section 2, kind of on the lower half of the page. Not a problem. It's just we've never used it. To our knowledge, we can't find any time we've offered an honorary membership, so it removes that. Next problem, section 3. There are 2 places where these bylaws reference the Maddie Insurance Trust. Well, that's a separate organization, and there really shouldn't be any mention of it here. So we've removed those to say, no, there's no connection in the bylaws there. Maddie, these restrictions here that are reflected in section 3, Maddie has those and Maddie can keep them. but it's not something that should be put in the MAT bylaws, okay? I've also defined the term voting officers, and you'll see that pop up. So for example, you'll see here voting officers instead of members, because our towns don't really vote when they come to our events. It's not a township vote, it's each supervisor, it's each clerk or treasurer who votes, and I've reflected that to be more accurate to who votes, okay? Section 2 just changes. We don't have to kick somebody out immediately when they don't pay their dues immediately. We can give some opportunity to work for them, okay? Likewise, Section 3 is another reference to Maddie. We remove it, okay? Here we've cleaned up what the annual meeting is. The annual meeting is the same meeting we always have. We just change to make sure we have a consistent term, okay? Section 4, we removed a requirement to use Robert's Rules of Order. For those who've listened to me before, I don't like Robert's Rules of Order. They're terrible. They're very, you know, if you're going to create a set of rules, fine. It's very nice for a set of rules. It really doesn't work very well. And while we say we use them, we don't strictly follow them as it is. And I don't think it has to be said in this document. It creates a problem. It creates the assumption that everything has to be done by Robert's rules. Instead, we remove it. And we do what many other organizations do. The members at the annual meeting can adopt a set of rules at the beginning if they want. If they want Robert's rules, fine, they can vote it in. But I think most likely they're going to operate in the informal way we usually do, where they already recognize a motion and a second, and we have a shared sense of how the procedure should happen. And the body itself will decide if there's a rule question. They'll take a vote rather than have me search through a 700-page rule book for a question that probably doesn't require that 700-page rule book. So it removes that. Section 5 removes proxy voting. We don't see a lot of proxies. A proxy is letting somebody else exercise your vote. We don't see it a lot. It poses a burden really on our staff, okay, to manage this proxy system, if somebody to use it. It also encourages people, if you want to vote, show up and exercise your vote on every item that we vote on. Don't just give it to somebody else and they'll exercise it the way they want, okay? It prevents that. We hope it gets more buy-in to these meetings. Stylistic changes there in Section 4. Okay, the Board of Directors section, largely the same. It's not a lot there. We've updated the voting officer mention. Okay, we've made it clear that we represent people, which we do. The Section 4 there on director says, well, we're supposed to have districts that are roughly equal in population and size. Well, size is a difficult issue to deal with when we have more density towards the metro area and less as you get further out. So we've said, no, our district should be based on people, not area. And we've made that change. I don't anticipate a change in the district boundaries right now. That's not been discussed. It's just that we're going to say when we do that, it's going to be based on people. Election of directors, this is stylistic. This first section, it doesn't change that process, okay? On the election of directors in the normal course or regular election. What we do address are a couple things here. One, no more running from the floor in a district meeting. Our members and our board have, I think, an interest in fairness to know who's running. Everybody can put in a candidacy form if you want to run, but this stops elections by surprise. I don't think that results in better results, a better system for our members. Okay, we don't get a chance to really have those candidates explain themselves and who they are. Whereas in other times, our candidates have had discussions before the district meeting and people openly know who their options are. Some people attend a district meeting knowing there is going to be a contested election, or they don't because they think there's not going to be one. And then by surprise, there is one. We remove that election by surprise in these proposals. Okay. Vacancies. There's a number of things with vacancies. One issue is that, and I'll touch on it later, but a vacancy wasn't defined before. We've added what are a vacancy because certain things that could have happened before, like a resignation, didn't actually create a vacancy in these bylaws. And that doesn't make a lot of sense. So we've clarified that and explained directly that the board has two options when it comes to a vacancy. They can call for a special election in the district, or they can appoint. Those are already in the bylaws. It just, I don't think they're very well stated so people understand what the board could do. Traditionally, the board has opted for elections, but there may come times when it doesn't make a lot of sense to hold an election or the timing doesn't work. Okay. And so this states very clearly and directly, there are two options here. So no town officer is surprised by either of those options being used. Also clarifies when they start and when they end the terms. Okay. Here we have the vacancies. We've added the 4 items that trigger a vacancy. Some of those were not listed before. Now we make them clear. Discipline's the same, just changes to the, again, MAT instead of association. It does add a statement of fiduciary duty, which is already the law, but here again, it states it very clearly that they have to follow fiduciary duties imposed by law. Here again, mostly stylistic stuff. Oddly, the secretary section here used the term assure instead of ensure, and I think there is a difference. I've switched that so it's clear the treasurer has these duties and not just to say that these things are done, but to provide that they be done. All right, amendment. This is the last section we have. Here again, I think we have a confusing process. There's 2 processes listed. One is that the county units can bring forth a resolution at least 180 days before the annual meeting. The board has to approve it before it could go to the members at the annual meeting. That's one method. The other method is the board itself decides to forward a set of bylaw changes at least 60 days before the annual meeting. And that's the one we're in right now. The board offered these changes. Okay. Well, we've had questions. Well, wait a minute. How can you do that? For example, Jeff was on district meetings talking about bylaw changes, and some people said, well, you can't do that. You're past 180 days. It's because they didn't read the whole thing. It created confusion. And here, no matter the change and which way it comes, it has to go through the MAP board. So what we've done here is get rid of the requirement that a county unit have to be involved. That no longer would be a hurdle. Any individual voting officer could forward a change to the board or a district director and offer it as a change. If it's a good idea, it doesn't necessarily have to go through a county unit. Okay. There are other issues with county units that we've had over the years defining what they are. Doesn't even have to be only one from a county. There's all kinds of issues with county units. So we just say, we're not going to use them as a basis for anything we do here, especially not knowing what they are and how they can all be very different. Okay. Good ideas can be forwarded on the basis of a good idea from one person. That's the language it provides here. It's a restatement, I think, more directly telling people these can happen in either way. Okay. Now there is an alternative to this language that the board has talked about, I think, may offer to consider here, and I'll share that. In addition to the 2 processes we have in the bylaws themselves, MAT's subject to a corporate statute, right? It's a statute for what allows you to be a corporation in the first place. Okay. And that thing has a set of rules that we also follow. It's not just the bylaws. We also have articles of incorporation. And then we have rules that are provided in law that we can't change no matter what you try to put in the bylaws or the articles. Okay. So that section or that statute has a section that says, unless the articles say otherwise, the articles of incorporation, power to change the bylaws is vested in the board. Graham, again, can you confirm you're seeing a new document? Thank you. Okay, it says the board can do this on their own, subject to like a recall or a reverse referendum power of the members. This language you have here in italics incorporates what that statute says. And I think this is the most honest description of the possibilities. Now, whether the members like that or don't like that, it exists whether they want to pass this language or the other language we proposed. Okay, this just says it straight out. So there's no surprise, again, if the board at some time decides, hey, we have a problem we think we have to fix right now. And yes, it's subject to recall or change by the voters later, but we're going to do it for the short term at least. Okay, and that's this language here. It says can be amended by the board itself, pursuant to this section 317A181, and that's where it comes from, or the board can say, hey, we're not gonna make this change on our own. We want to do the 2/3 majority process of the voting officers like we have now. Okay, both are provided for. Both, again, retain, it's got to go through the board first. That's the same as it is now. Okay, the notice is the same, has to be provided to the members, usually through the insider in advance of the annual meeting. Okay, and that would be the method to do it. Those are the proposals we have. Those are the problems I think we face and some things to address. Okay. So it looks like some questions here in the chat. I'll take. Can we print these? We're going to send them, Pat. Okay. We're going to send them to everybody. All right. And I'm finishing up a description. That's what that extra piece is right now, that you just viewed. That was in a memo that's going to explain. Here's everything in it. Okay. And I want to have meetings, whether it's online or in person. Okay. So that people get questions out. I don't want it the day of the annual meeting, because we're going to feel hurried or rushed and people are going to say, well, I'm surprised. No surprises here. Okay. So they're going to go out. We're going to send them. Okay. Jeff mentions rules of parliamentary procedure. We'd still have a parliamentarian. Okay. And the rule, usually me. Okay. Decisions of that parliamentarian are subject to change by the body and should be. Okay. It's just, we're going to say, we're not going to establish a formal set of rules unless the group wants to. Now with our own board of Matt, 13 people, they were thinking they were under Robert's rules. They really weren't, but we've discussed, well, should we go to some other option? And there are other short options, 20 pages, 25 pages of rules that we've looked at. Okay. Graham's put together well, here's kind of how we've functioned. Summary set of rules. There are a lot of options there. So I think those are better choices for the group to be able to decide what they want to do in that moment. So Jeff mentions, yeah, we're making it easier to present a resolution. You don't have to have the county unit's approval, and that can't be a stop to you presenting something on your own. Okay. So and Jeff answered 13 members of the board. So feedback, comments, questions, what have you got? This is the first group we're showing these to. So let me know, please. What do you think? Maybe you don't care, and that's fine too.
Just answer, she doesn't care.
Well, I kind of said these things often don't matter to people, and day to day, we don't look at these. We operate, we have methods of operation, and these we don't always look at because they don't provide for everything. They're supposed to give us some rules, but also flexibility so that we can do what we need to do. So.
Yeah, we won't send you the 714 pages, Pat. Don't worry.
You can buy it on Amazon if you want. It's a terrible book.
Yeah, here it is. Oops, okay, can't really get it in focus.
It's math. It's just crazy.
It's thick. Yeah.
In contrast, democratic rules of order, tiny. Okay, there's a lot of options. So. All right. Any comments? Any questions? I really do. Please. What do you think?
You can also email Steve later on too.
Yeah.
If you don't feel comfortable asking it right here.
All right. Either don't want to ask in front of other people, don't care, as Pat has mentioned, or we don't know what to ask. So that's fine. Okay.
Go Twins.
Go Twins. I love that. Fantastic. Yeah. Yep. All right. That's all I have then for today. Thanks for listening to it. If really, let me know if you don't care. Tell us you don't care, because that's valuable too. Okay, to take to some of our directors and some of our other officers who say these are the utmost importance of everything in life, and we say, I don't think so. Or are they just little changes and they're not going to be a big deal to you? So let us know. Looks like Graham is done. Maddie, you did a good job. Well done. Okay. She's 105, extension 105.
Yep.
She's waiting for calls.
I put everybody's direct dials in the chat, so go ahead and grab that.
But especially Maddie's.
Exactly. I'll put that in the poll.
Right.
Yeah, please do.
Yeah.
Well, thanks everyone for showing up and for attending this Township Tuesday. Again, please feel free to reach out to us if you have any questions. Otherwise, we'll see you in 2 weeks, and I hope to see you all at the annual conference. Take care.
Thanks for your time and attention, everyone.